we are recording and we are live. Mr. Chairman, do you want to give any reviews, just kind of a note of what we're doing right now? Just thinking if anyone's watching, just. Okay.
Yes, right there, Jack. I'm surprised you did.
We're looking for you.
Sorry. How you doing? Good morning. My name is John Payne, and I'm the chairman of the Draft Permitted Plan Tribunal appointed by the minister responsible for the Department of Planning. Along with me today are members of the panel, Carlos Amaral on my right and Jennifer Howard on my left. Also present is Dorian Thompson as technical advisor to the tribunal, Larry Williams, also technical advisor to the tribunal, and Mandy Shaler, who is our IT specialist. Because of the current World Health pandemic situation, these hearings are held virtually via Cisco WebEx and open to the public via YouTube. However, physical distancing is permitted for some representatives. And based upon the Ministry of Health recommendation, only 2 persons per party is permitted in the physical location which is the boardroom of the Department of Planning. And during the hearing, unless you're speaking, they must wear masks at all times. All material being presented to the tribunal has already been circulated, and each member and each person should have been privy to what is already to be discussed. For those who are accessing remotely, please be reminded that this is a public hearing and you are visible to others. Please ensure that when you are speaking, if you are given permission to speak, if you're not speaking, sorry, that your speaker is muted. Those are my opening remarks. The first case this morning consists of a policy objections to policy IND 5, and on behalf of the objectors are
Donald Gray.
take your mask off when you're talking.
Donald Gray.
And
on behalf of Donald Gray, Peter Sanderson from Beesmont Law Limited.
Can you, when you're speaking, be a little louder so that it can be picked up in the speakers?
Mm-hmm. Yeah.
And on behalf of the Department of Planning?
Kenny Campbell.
Kenny Campbell. Okay. Mr. Gray, you represent a number of persons. In fact, there are 13 objectors. And you have been given authority to speak on behalf of all of them?
That's correct.
Okay. It is your objection. So,
well, I'm engaged here by Mr. Gray and the other objectors to speak on their behalf. So
you'll lead.
I'll lead with the objection and the proposals. So this is relating to IND 5, and specifically a proposal that IND 5 should require public road access for industrial sites, and it's really submitted that that this is for the aims of consistency with other aspects of the policies. For example, the quarry policies require public road access, as does industrial use in residential zoning. But for some reason, industrial itself does not have that specific requirement. Now, this comes. The objectors are particularly concerned about Earls Lane and Lollie's Well, but really illustrates the wider issue here. So this is an area that's now a fairly substantial industrial area in the middle of what's otherwise a residential zone, and was given industrial usage permission some years ago, despite the fact that it did not have public road access, and that was probably done in error or without regard to the policies. And so it's created this particular issue, and I'm sure the panel members are familiar to some extent with the site, and it's an area where you've got a fairly steep, narrow access road up Lollie's Well, which bends and turns, and is used by a significant number of vehicles every day, and at all hours of the day. I mean, these are obviously industrial businesses. They often like to start early, and they want to get as much work done as they can during daylight hours. And although planning has imposed conditions on the sites, which are set out in the objections, that there are restrictions as to operating hours, it really is a challenge of enforcement, because planning are not going to have the resources to be going there, checking on people, issuing stop notices. It's a very difficult thing to enforce, to make sure that all these different businesses, and not just those businesses, but people who might be visiting those businesses, other companies that
So your issue is it policy or is it enforcement?
Well, it illustrates the enforcement challenges illustrate a problem with the policy, because these are hard things to enforce when you're dealing with multiple vehicles every day. It's a challenge for planning to enforce that, and it's difficult for neighbours to have to be constantly.
So you're speaking on behalf. So you're speaking on behalf of the Department of Planning.
I'm speaking on behalf of the objectors.
You just said that planning can enforce, so I just wondering if you're speaking on behalf of the Department of Planning.
I'm submitting that enforcement is an issue. I'm making that as a submission. that it's a challenge to enforce these types of conditions. And that can be tackled by having policy that gets things right from the outset. If you have clear policy that that these types of areas need public road access, then from the outset you get things right, because then you don't get into issues where you don't have sufficient access, and then you're relying on having to always report things to planning and relying on plan to enforce. You simply have the right policy from the get-go that says that you need to have public road access. And the objectors have looked at various other industrial zones in Bermuda, and they've got a list of 6, which includes Harvey Road in Paget, Jubilee Road, Devonshire, Hermitage Road, Devonshire, Beasley Street, and Parsons Lane in Devonshire. And all of those do have public road access, and it seems that the Earls Lane is the odd one out. So this is something which it's an anomaly that seems to have been created, and really that anomaly could have been avoided if there was clear policy that you do need public road access to these types of developments, because otherwise it does have significant impacts on neighbours. And there are a lot of neighbours, a lot of residential units who live around here who have to deal with the noise, pollution, and traffic and vibration, dust, all of these environmental issues that affect the neighbours and their properties. So I mean, this is a place that these types of areas need public highway access for the purpose of safety and environmental protection. It's and it really is a question of consistency, that if public road access is required for industrial use within residential areas, that's already clearly in the policies, then the same should apply even more so to actual industrial zoning. And is there anything else that needs to be said?
No, I think that pretty much summarises it.
I just have a few points that I want to make, which...
Can you speak up louder, please?
Yeah. I just have a few points that I want to make, which address some of the concerns raised by the objectors and basically reflect the content of the Department Position Report. The objectors want to insert a criterion into policy IN5, which requires all industrial sites to be served directly by a public road. The first thing to say is that the policies of the plan are used to assess planning applications. They are not used to assess the merits of a zoning proposal, create a new zoning. So to insert a criterion into the plan to state that all industrial sites should be served directly by a public road does not address what the objectives are looking to achieve, which is to ensure that all industrial sites, when zoned, are served directly by a public road. The zoning process takes place at an earlier stage in the process, point at which policies of the plan are relevant is in the assessment of planning applications, not in the consideration of objections which propose new zonings for sites. So that's the first point. Second point is that you could potentially have a scenario whereby the minister decides to zone a new area as industrial, which is not served directly by a public road. As we know, the department only makes recommendations to the tribunal. The tribunal only makes recommendations to the minister. So the minister can decide upon new zonings using whatever information he wants. He can completely disregard whatever the department or the tribunal puts before him. So you could have a scenario where the minister zones a new industrial site which is not served directly by a public road. And if the objectors get what they're looking for today, at the same time as this newly zoned industrial area, you would have a policy which says you can't actually develop that site for industrial purposes because it has to be served directly by a public road. So from a planning perspective, it's what the objectors are looking to achieve is fundamentally flawed. Now the objectors have referenced...
1 minute. Are you saying that if the objectors got their wish with respect to a policy amendment, that the minister has no discretion?
No, what I'm saying is you would have a policy which says you have a scenario where the minister has zoned a site for industrial, which is not served directly by a public road. You would then have a policy which effectively says, directs the Development Applications Board, they cannot approve an application for industrial development in that industrial zone because the policy would say as such. That the minister, someone could obviously appeal that decision through the appeals process, and the minister would have jurisdiction in that regard. But you would create a clear tension between what the policy says and the zoning of a site in that circumstance. Okay.
Good, continue.
Can I ask a question?
No, not yet.
The objectors have referenced two policies in an attempt to support their case, which specifically require land uses to be served directly by a public road in two circumstances. One of those policies is ISD 43, which requires proposals for light industrial development within residential 1 zones to be served directly by a public road. So in that scenario, it has not been predetermined that specific geographic locations within industrial zones are acceptable for light industrial development. So that's why the plan contains that criteria to ensure that there are policies in place which are equipped to deal with applications which could be proposed in any residential 1 zone. So that's different from industrial development within an industrial zone site, where there has been a determination that the principle of industrial development is acceptable within an industrial zoned area, and that determination has been made by the minister in his zoning of industrial zoned areas. The second policy that's been referenced is QRY5, which is a policy that's used in the assessment of, again, planning applications for quarry development. Similar to the point I just made in terms of ISD 43, there has been no predetermination as to where quarry activities would be considered acceptable through the zoning process. There's no such zone as a quarry zone. So it's therefore necessary that the plan contains criteria that can be used to assess planning applications for quarry development. And again, just to reiterate, that's different from the circumstances where industrial development is proposed within an industrial zoned area. Because in zoning that area industrial, the principle of industrial development has been deemed acceptable in those locations, in specific geographic locations. Now, the second part of the objector's initial submission has referenced numerous perceived breaches of plan controls. The majority of these are enforcement issues, and they have been forwarded for the attention of the Department's enforcement team.
You said you had a question to ask?
Yes, okay.
Right.
What we're talking about, what we're talking about here is an error on the part of, as Peter mentioned earlier, when planning permission was granted to the Corrado property in 1999, that was in direct violation of the planning statement that was in effect, the 1992 planning statement. So they granted industrial development in a residential area without adhering to their own policy at that time. What we're trying to do here is prevent a repeat of that sort of thing. It was compounded by, as I said in the rebuttal, by a rezoning in 2008. My question relates to the gentleman's comment about the minister. The minister, surely before proposing to rezone an area to industrial, would take the advice of his technical officers in the Department of Planning. Now, would that not be bound by their recommendations? Surely would be bound by established principles, sound logic of, if you're going to do industrial, these are the criteria that you need to meet. Why would he arbitrarily just say, I'm going to choose this part right here to rezone this as industrial? And rezoning as industrial, as I understand it, goes through a process allowing objectors and what have you to be heard. It's not quite as just on a whim as the gentleman seems to be suggesting.
I don't think he suggested that, right? But what he was basically saying is the minister does have the right to do certain things.
Sure.
And even as a technical officer, you can make a recommendation to a minister.
Understood.
but based upon every logic that you can think of, but it's still the minister's prerogative in law to do what he or she feels is appropriate to do at that time.
And they open themselves to appropriate challenges.
And they have, exactly.
But I think the submission being made is that the starting point as a question of policy is that for industrial zoning that there should be public road access. If in a particular application somebody is wishing to get permission for an industrial development and does not have public road access, then potentially they could appeal to the minister, I guess. And if the minister, in his discretion or her discretion, felt that given the wider public policy, that permission should be given despite the lack of public road access, then perhaps the minister could make that determination. But the submission being made is that the starting principle, as a matter of good policy, is that there should be public road access for industrial zones and for industrial development. That should at least be the starting point. As you say, the minister has discretion at the end of the day, but that should be the starting point as a matter of policy, is the submission.
Mrs. Howard, do you have any questions? No. Okay. You have anything else to add?
Well, it's not really, just to go back on that point, it's not really a matter of policy because there are no policies which guide the zoning process.
No, but for a development application,
yes.
If somebody, for example, in an industrial zone, puts in an application to actually build an industrial development, then they would the board needs to check that the policies are being complied with.
Right.
Yeah. So that's the issue. So, for example, just taking this one as an example, Else Lane. If somebody in Else Lane today puts in an application for a new industrial development on Else Lane, it's industrial zones. They can make their application. And okay, there are other policies that look into the impacts on neighbours, but there's nothing specific about the road access.
If the minister has determined in that circumstance that site is appropriate for the principle of industrial development, regardless of the access arrangements, the minister has made that determination on a decision which was made 10 years ago in zoning that site for industrial development.
As a matter of, but the point is that simply as a matter of starting point for policy, that there should be public road access.
Well, I think as we'll see as we go through this process that in any instances where a new industrial is zoned, a new industrial proposal has been put to the department, that the access arrangement is formed an integral part of our considerations. However, as I said previously, the minister can completely disregard, as the tribunal members are aware, any information that we put before them.
Okay.
Thank you.
Thank you. Big. Mr. Williams, can you escort them up, please?
Yes.
Kenny, are you presenting? No, that's Nate, right.
Thank
Nate
you.
is the one.
We'll have you come up this door.
Yep. Let you know you can let them out.
I was gonna let you out this door. It'll be easy.
Hmm?
Just to note, folks, one of our viewers did comment that, asking if the volume could be louder, so that we've kind of got things up as high as we can, so maybe just another reminder to our presenters to really project their voices,
Okay.
will help, so.
Yeah, both of these two are sort of naturally soft-spoken.
Yes.
You're courageous and informed, she can't hear a thing.
Oh,
Yep,
She can't hear a thing.
nothing I can do. Yeah, no, it's a good thought. Just like, hang on, no. I'm gonna get one of the IT guys to jump in.
wait till Mr. Williams comes back, and then we'll proceed. Good morning.
Good afternoon.
Not quite.
Sorry, not trying to.
Not quite afternoon. Not quite afternoon
Oh,
yet.
oh, that's right, it's 11:15. Good morning, sir.
Afternoon
Yes,
somewhere.
Sorry,
Yes.
felt later.
We're now dealing with case. This is a policy case. FWD 0245-19, and there's a objection by John Gardner for a policy amendment to RSD 27A. Present we have for the objector.
Mr. Gardner.
Can you speak up loud because the mics are?
Yes, Mr. Gardner.
You can take your mic off
Oh,
when
I
you're
can?
speaking. Yes, when you're
Okay.
speaking.
Okay. I am Mr. Gardner.
Yes. And for the Department of Planning,
Hi, I'm Nathan Frick.
Nathan Frick. Okay. Mr. Gardner,
Yes, sir.
you are objecting to the policy.
Yes, sir.
You have 5 minutes to explain why the policy should be amended.
Well, I've given a detailed rebuttal, so I presume everybody's read that. And has everybody read that? Yes, okay. So I won't go through that because that would be tedious. Basically, the impetus for the objection is having worked in the industry for many decades, and then you read the draft plan, sometimes some things pop up. And so this was sort of a universal objection. It's not personal, there is no client, there is no location. It's a matter of principle. And the principle that sort of underlies the whole thing is having a development plan where a government is as as supportive as possible to people in its framework. Clearly, the development plan is in place to manage an overall environment so that people's individual actions do not negatively impact other people's lifestyle, whether it's in the immediate area or from a country point of view. I believe in this one that the policy has been a bit static over the years. It's a good thing that you can have some form of business out of your house. But to restrict it just to two people just seems particularly limited. It seems particularly limited in that with technology, you can have more people with low impact, and I've tried to be articulate with that in rebuttal. I think the issue is not the number of people. I think the issue really is measuring the impact on adjacent properties, so I think, interestingly enough, I believe it's been clairvoyant because this objection was filed in March of last year, and lo and behold, this year, we find as a result of the pandemic, people now working at home really quite happily. There's much more intense use of people, not necessarily running a business, but I do know of cases of people running businesses out of their houses. I'm not here to mention them successfully. And I think that's the future, and you sort of see similar things with sharing economies where people are sharing, that whole sort of division between what's private and what's public is blurring and making maximum use of resources in a positive way. So if someone can run a business with 3 people, maybe 4 max, and do it within the guidelines that are in place, I think it's a good time to test that, and events this year have proven that it might be timely indeed. The government case has mentioned a number of reasons why not to do so, in particular, change of use and commercial density and stuff like that. There's always been excess commercial capacity on this island. When we did Cumberland House in the late 80s, everybody was saying, we were doomed. There was too much office space. Since then, the whole Parlour Road basically got built up. There's always going to be commercial capacity. I don't think that's the issue. And also in terms of creep, which is a very reasonable concern on planning's part, that someone gets in with a business and then they get out of hand. I agree with that cautionary position. But I think that can be managed with the provisions in place. And as I stated in the rebuttal, The plan is quite clear in terms of what constitutes a material change of use on property. So all you have to do is apply the material change of use parameters as a part of someone being able to do this work in their house up front, and then you minimize or eliminate the risk of it happening in the future. So that's kind of it in a nutshell. I think I'm just here to sort of put a bit of a voice to the text to help you understand I think it matters why one objects as much as what the objection is, and my intention is for the good of the community, and particularly for individuals to be able to be as free as possible and as happy as possible in their lives with the fewest number of restrictions. I think this opens the door a little bit more for that. Thank you, sir.
Okay.
So kind of, apologies. So to echo what Mr. Gardner said, providing just a voice of what the original written response to the objection that the department has submitted. As he correctly mentioned, the definition of a home occupation has been consistent in previous Bermuda planning statements. 1983, 1992, and all 2008 plan have stated the exact or similar wording to the definition of limiting to 2 persons, with one being the primary resident of the house. The concern that the department has is one of distinguishing and what is a home occupation versus what would constitute a material change of use. Some jurisdictions can be more lenient that we found, but other jurisdictions are even more strict, allowing only one person, self-employed person, to operate as a home occupation within their house. So we find that that having 2 people can be considered reasonable in comparison to other jurisdictions. So part of the reason why we have home occupations and material change of use is to have that kind of distinction, especially when it pertains to residential zonings. So for anything that exceeds the definition of a home occupation, we consider that a material change of use, and it's put under policy RST 37. The main limiting factor with policy RST 37 is that while residential 1 zonings can permit new forms of commercial development or mixed-use development, that does not apply to residential 2 zonings. Residential 2 zonings, while they do allow existing commercial development, intensification or brand new commercial development is not permitted. So the main concern, the crux of the issue, is that what we are worried about is maintaining the flow of traffic, the flow of people in residential 2 and lower density residential areas, and we feel that having 4 people would increase the traffic being served to those areas, which would increase the intensity of the neighborhood and its use. As you correctly pointed out, another argument that the department is very keen on is being able to use what existing office space we do have. Currently, we have, as you correctly pointed out, an excess use of office space, especially in Bermuda, and part of the direction the department wants to see is having commercial uses being used more effectively, more efficiently, and such larger scale forms of commercial ventures can use those additional uses. We don't see that there is a reduction or a shortage of areas to do small to medium scale businesses. Therefore, we don't err on the side of wanting to increase the amount of increase the policy RST 27A. Yeah.
This policy was developed or fine-tuned pre-2020.
Yes.
Mr. Gardner gives the statement that given the pandemic and the current state of affairs of the world, more persons are working from home. Is there any possibility that the Department of Planning would reconsider this policy in the light of what is now being expressed as a new norm?
Well, as a singular voice, I don't want to speak wholly on the behalf of the Department of Planning, but as we've seen things change over the last few months, as you're correct, and in the future, there could be a possibility of certain definitions being changed. within certain policies in the draft, in the Bermuda plan. That is something that we could revisit. Like as been said, the purpose of the 2018 plan is to be a living document. Therefore, having able to do policy amendments and stuff as it is being tested and retested and examined, that could be brought up. However, these are still fairly early days on seeing what will life look like post-pandemic. And to that, it will be something that we consider, but not right now, maybe later.
In your submission, you indicated that you consulted, there been some consultation. The government of Bermuda is pushing for small businesses.
Yes.
And therefore, did you consult with the Small Business Development Corporation or whatever the name is now?
So I should make clear that this policy objection was not written by me. It was written by my supervisor.
Your representative department.
Yes.
So therefore, do not come in front of me and tell me it wasn't done by you. If you come in front of me, you're speaking on behalf of the department, and therefore you are speaking on behalf of the department.
Well, the point of what I'm saying is that I won't be able to fully answer that question.
Then that's the appropriate response.
Sir, may I interject?
Yes.
I did ask the question of the department regarding data supporting the policy, and my understanding is that there is no data supporting the department policy. It's really a continuation of the previous policy without research. And maybe I'm overstating that, but that was my sense from things, because there was nothing to support numbers of businesses, complaints, or small business development research. It's just sitting there as a continuation.
Thoughts?
I mean, some legitimate points that have been brought up.
They can't hear you.
Yeah, I'm fine with the points that you proposed, some legitimate points that need to be addressed and taken into considerations. Appreciate that.
I don't have any questions or anything.
Thank you very much, Mr. Gardner.
You're welcome.
Thank you.
Thank you, everybody. Thank you, planning. No offense intended anywhere, just trying to
No,
jump
No,
around.
not at all.
That's all right.
Take care. Have a good
Take
day.
care.
Take care.
Townsend, thank you for the good setup work.
Oh, thanks, Tom.
Yeah, you can go there.
So, as you know, Bermuda National Trust is not going to be presenting, right? So,
Who's representing them from planning?
Me.
Nate is the officer for both the remaining three.
Would you like me to come back out and then come back in? I was actually, I felt like that was one of the things.
Okay. The next case is FWD 0252-19, and the objection is Environmental Analysis and Conservation Management Plan, and the objector is Miles Darrell, and Mr. Darrell represents the Bermuda National Trust. He has decided that they will stand on their written submission, which basically he is asking for consideration to be given for the creation of a new body that would call the Environmental Impact Advisory Body, which is similar to the Historic Buildings Advisory Committee or the Advisory Architectural Panel, that will be able to look at environmental analysis and conservation management plans before decisions are made by planning. So he believes that this extra body should be created and have input before decisions are made. That is their National Trust position. The department's position?
Yes. So the department's position, first to note that this issue was previously raised at the 2008 Objections Tribunal, and almost the identical objection, and this was supported by the department, tribunal minister. They didn't think that it was necessary to establish an environmental impact advisory body. So just a bit of for the avoidance of doubt, such bodies like an environmental impact advisory body are legislated by the government. These include such as architectural advisory panels and the historic building advisory committee. These are bodies that are legislated by government to be consulted on when the need arises. However, this form of an environmental impact advisory body has not been legislated by the government to act. Generally, when it comes to conservation management plans or development application plans that require input, such as encroachment of the setback to a conservation area or development that might be contentious or in conflict with environmentally sensitive areas, there is a procedure that we currently have that has continued to act, where we would conduct with other members of government, particularly the Department of Environment and Natural Resources, for their input on how we should proceed and what direction we should take, or recommendation we should provide to the Development Applications Board. So mostly we have a terrestrial officer and Department of Environment and Natural Resources. We have someone who responds to the marine impact, and we have an environmental engineer that also deals with cave and any form of geological impacts that development may have in cave protection areas. Those are the people we tend to consult, and they provide us with feedback as part of their job remit. So that is something that we consistently refer to, and we're being well advised by those existing consultees and boards, with no real issues to that. The same goes for conservation management plans. We consult with Department of Environment and Natural Resources, who gives us their sign-off and blessing. They're the technical advisors that assist us with those submission of those plans.
Any questions?
Straightforward enough.
Yeah. Okay, thank you. The next matter is FWD 0262-19, and is a Section 34 agreement. Again, the National Trust has decided to stand on the written submission. For the record, Section 34 is a legislative part of the Planning Act. And I am not sure whether it should be discussed, but I will allow it because legislatively we're talking about policy and development plans, and this really speaks to legislation. And I think there's a different forum if someone would like an amendment to a part of the legislation, but we will allow some discussion. So their concern is that agreements under Section 34 of the Act can be amended with no public involvement, meaning that their use in the planning process, a public process, is not an effective tool for restricting and regulating development, especially when using them to present a planning gain to allow non-conforming development. The National Trust does not believe that they should be continued to be used in such a way unless amendments to any agreement are publicized and the public are effectively allowed to participate and have input. That is their position. The Department of Planning's position is?
The Department of Planning wants to give minimal comment to this, seeing that, as was mentioned earlier, Section 34 agreements are agreement that is done between the landowner and the minister, and whatever agreement comes from that is the result that it happens. There is very little that policy, directly or as legislatively should impact the decision that a minister or a landowner agreement should enter into. We do note the objector's comments. Section 34 agreements are not part of the draft permitted plan 2018. Like I was mentioned earlier, this is simply between the minister and the landowner. We don't want to comment much further on that.
Okay. We have no questions. All right. And our last case for the day is FWD 0276-19, and it's policy recreational 6. And the objection, the National Trust is standing on their written submission, and their objection that they find Rec 6 ambiguous and potentially damaging to existing / fallow recreation land. While the objector recognizes the need for support and auxiliary structures for recreation land, it is concerned that where there is not currently a function for a particular recreational site, such as Riddles Bay Golf Course, that this may be used as grounds to develop the area extensively. Does the Department of Planning have any comment?
Yes. The intent and the implementation of policy REC 6 is only applicable to active and functioning golf courses that are open, golf courses that are acting as a golf course. So the intent of the policy was to provide some sort of economic support to golf facilities by permitting the development of ancillary tourism accommodation on a golf site and recreation, which is something we thought made a lot of sense given the the symbiotic relationship with golfing and tourism. This is something that we want to support and continue to support. However, policy REC 6 loses its relevance when that site is no longer a golf course. And that is something that we want to make clear to the tribunal, that this could not be used in a situation like Riddles Bay where it's no longer a golf course. The minute that it closes up and does not intend to be a golf course in the future, policy REC 6 does not apply.
Any questions?
Nope.
Others? Okay, cool. Thank you. Those are the cases for today, and this hearing is now publicly closed. You're making 12:30 or 12:20.
No, well, I'm going to the government administration building, so, and I'm hoping that the
Discussion?
person on the other side sees reason and logic and doesn't make me go for an application that would be incredibly silly, but
Okay.
I live in Hope. I was gonna swing around there, so
Yes,
I'm not
yeah.
in a line.